Constitutional Court has reserved judgment in a landmark case concerning consent in sexual offences. Well, the outcome could have a significant impact on how sexual offences are prosecuted across South Africa. For more insight on this now, we speak to attorney and director at Dubazana Attorneys, Nthabiseng Dubazana. Thank you very much indeed for your time. And I guess one of the first issues that I looked at, Ms. Dubazana, was the applicants here seem to want consent to be removed as a defence. If I'm correct, talk to us a bit about this.
Good morning, and thank you for having me. So yes, that's what the CALS, the CALS, want to happen. So currently, as we look at the Sexual Offences Amendment Act, it gives the accused a defense in that consent can be used as a defense. Remember, when it comes to criminal matters, the state has to prove its case beyond a reasonable doubt. So, for example, if I'm going to be saying in a theft or whatever, and say I have an alibi, I was at Griselda's house. It is the state's job to go and check with Griselda to make sure that indeed I was at her house. That way, they can cross it out and say you were lying, or they can confirm it so they can remove me as a suspect. With that example in mind, when it comes to sexual offenses, the accused has the option or the defense available to him or her to say that I had consent from the complainant. I did not force this person to have sexual intercourse with me. So what the CALS is saying that consent aspect is unconstitutional because it compromises the complainant's rights to freedom, equality, and the likes, by saying that if the accused is given that option of defending and saying consent was present, then it's putting the burden of proof on the complainant to say that they must prove that they didn't give consent. But that is actually the core of what criminal law is. The one who alleges must prove. So if you're saying that you did not give consent, then you must show that you did not give consent. So that's the CALS argument. And then on the other side, the Women's League, I think it is actually on the opposite end. It is the amicus curiae in this case. They are saying that if the court is to say that the accused has to show that there was consistent and objective consent that was given, it may also be viewed as coercion on the part of the accused.
And even though, judgment has been reserved, what would the consequences be should the Constitutional Court confirm the applicant's argument?
I think as a defense attorney, I'm a little bit torn in what it could mean, because when you defend people who are accused of rape, most of the time we see the things that the media will not be able to see. So we see communication between the accused and the complainant. We hear evidence on what the relationship was like. It's not all the time that rape is a situation where you were grabbed on the street, you were thrown, you were raped, and then it is all that horrible thing. But usually it happens in a domestic relationship, a love relationship, or some kind of we're getting to know each other relationship. And then now the accused is mostly the guy, and he is now standing there saying, but I never forced myself on this person. If we look at the case that was decided by Advocate Ngaito when he was acting judge in the High Court, he had said that it was subjectively reasonable to believe that the accused had consent to continue with penetration after there was a whole lot of oral sexual contact that was happening, kissing, taking off of clothes. So it was reasonable for the accused to believe that he had consent to go all the way. And that was overturned by the SCA. So this is the little gray area that we are finding ourselves into. So if the Constitutional Court confirms what the High Court has already said, to say that consent must be removed and then the accused must show that at every single stage there was consent, then it's going to end up saying that the complaint is saying, but he was forcing me to agree eventually. And remember, submission is not consent. And if it's not consent, it means it wasn't voluntary. And if it wasn't voluntary, it means we're right back to square one, wherein it's rape. So what does it mean? Would it mean that now the accused has to have a contract in writing at every single turn that she consented to a kiss, she consented to this, she consented to that? What would that mean exactly? So I think that is what the court has to grapple with, because it's going to really change the dynamic on how we defend and also prosecute rape going forward.
And I want to talk a bit about that. I mean, how do the biases around consent currently affect, criminal cases? And, in what ways could, this judgment address your social, your cultural, or even, gendered assumptions?
So, unfortunately, rape is always a situation where the man is the accused. It's very rare where you're going to find the woman being the accused. With that being said, in criminal court, we see a lot of men being falsely accused of rape. And as a result, because the woman said, I never gave consent, and they give whatever evidence they give on the stand, the court, for whatever reason, is always swayed, not all the time, but it's always swayed towards the woman. And then this man ends up spending time in custody for something he never did. I remember there was a case I did many moons ago, wherein this woman cried rape only because this guy made her spend $150. He spent 9 months in prison. And then on the day of trial, she said, if he pays me back my $150, he can go free. These are the kind of dynamics that we're dealing with. I just dealt with one a month ago, wherein even the witnesses confirmed that there was a relationship, there was kissing, there was voluntary, all of these things. But the girl came out and said that, but I didn't give consent. My guy has been convicted. So we are dealing with a situation wherein, as long as I say that at that particular moment as a woman, I did not give consent, then it is rape. Now, how do we then deal with the gray area? How do we deal with the social context? Because we have young girls, 12, remember from age 12 and 16, you can give consent. This is something that is not known in the law. It is assumed that you can give consent. Even under statutory rape, even though you're under the age of 16, we still can argue that because you're over the age of 12, you gave consent. So now we are finding 14-year-olds, 15-year-olds in clubs where 20-year-olds are there. We're not going to ask you for your ID. And then when we go and home with you after a night out, and then we go and engage in sexual intercourse, you're going to cry rape. So how do we deal with all of these things? So it is a very difficult position that the accused, whoever it will be, male or female, to prove that consent was given even up until the moment of penetration. I don't know how the courts are going to deal with the social aspect of it, because does it mean we have to walk around, like I said, with contracts? So it's going to be very interesting to see how it's going to be dealt with.
Yeah, and I mean, what impact could it have on the legal system, I mean, survivors, of sexual offences and, public understanding of consent on its own?
So with consent, it always has been a situation that it has to be freely and voluntarily given. Let me take an example of the Senzo Meyiwa case. There was a point whereby a statement was made and it was said by one of the accused that he never gave it freely because he was beat up, and then he ended up doing the confession. So there was a trial within a trial to determine whether or not that consent was given freely and voluntarily at the statement, I beg your pardon. And as a result, with that trial within a trial, it will determine whether that statement will be admitted as evidence in the main trial. So what do we do when it comes to criminal offences? Because there's no way to do a trial within a trial in rape cases to confirm whether or not, when there's two people in one room, that consent was given at the time. Do we then look at the surrounding circumstances that led to these two people being in one room, and whether or not it can be deemed that consent was given at that time? What would it mean when it comes to dates? When you're going out on a first date, what does it mean? Does it mean that you should go there prepared with every single thing box being ticked in a certain way? How does it determine the right to freedom, the right to engage with people? How do we deal or navigate that aspect? So I feel like the Constitutional Court is being put in a very hard situation. And I agree with the women to say that removing the issue of consent and forcing upon the accused to show that they had consent at every stage will lead to me as a victim saying that, but at every moment you were asking me, so can we do it? So can we do it? So can we do it? I eventually going to go like, okay, it's fine. Is that consent or is it submission? And if it's not consent and it's submission, therefore it means it's rape. So it's going to be very interesting to see how the court would have to bridge that gap between consent, submission and objectivity.
Certainly one will be watching very closely. Thank you very much indeed. Nthabiseng Dubazana, attorney and director at Dubazana Attorneys, providing insight into that landmark sexual consent case and, explaining the significance and potential changes and impact of the Constitutional Court's reserved judgment at this stage.